If you thought the first half of the 114th General Assembly was bad for your rights as an American, hold on. The second half has been the worst legislative session in recent memory, relative to protecting instead of stealing enumerated rights from the people. Not only did it not cure the problem of the Jim Crow intent to go armed clause, 39-17-1307A, as it should have, even though a number of bills attempted in various ways to accomplish this, Senate Judiciary Committee Chairman Todd Gardenhire unilaterally killed those bills by rolling them to the first calendar of 2027, and the other Republican members did nothing to stop him. This, after the three-judge panel in Hughes v. Lee ruled it unconstitutional. Instead, it passed a bill that will forbid such a case ever being filed again. House Bill 1971 says, Section 3, Tennessee Code Annotated Title I, Chapter 3 is amended by adding the following as a new section. A. Notwithstanding another law to the contrary, a cause of action exists under this section for any affected person who seeks declaratory or injunctive relief in any action brought regarding the legality or constitutionality of a governmental action of only a political subdivision of this state. A cause of action does not exist under this section, 1, to seek damages, or 2, to challenge the validity or constitutionality of any state statute. This flies in the face of the Tennessee Constitution's Declaration of Rights via Article 1, Section 17. Quote, that all courts shall be open, and every man for an injury done him in his lands, goods, person, or reputation shall have remedy by due course of law, and right and justice administered without sale, denial, or delay. Suits may be brought against the state in such manner, and in such courts as the legislature may by law direct. Close quote. We should be able to sue for prospective relief, but this law now denies that ability. It sets aside the maxim from Marbury versus Madison from 1803 that says, quote, a law repugnant to the Constitution is void. An act of Congress repugnant to the Constitution cannot become a law. The Constitution supersedes all other laws, and the individual's rights shall be liberally enforced in favor of him, the clearly intended and expressly designated beneficiary. It is a settled and invariable principle that every right, when withheld, must have a remedy, and every injury its proper redress. These cases often arise in the First Amendment context, speech, religion, association, but apply more broadly to other constitutional rights where a state law threatens to punish or burden protected future conduct. The injury is the imminent threat itself, the chill or deterrence to exercising the right, rather than waiting for actual enforcement. For example, these Supreme Court cases say, number 1, Susan B. Anthony List v. Dry House, 2014. The court unanimously held that a credible threat of enforcement, even without a pending prosecution, creates a sufficiently imminent injury for standing. Plaintiffs plan political speech that could trigger a state false statement law. The mere threat chilled their rights enough to allow a pre-enforcement suit. The injury was the prospective harm to their planned constitutional activity. Second, Pennsylvania v. West Virginia, 1923. One does not have to await the consummation of threatened injury to obtain preventative relief. If the injury is certainly impending, that is enough, close quote. You generally sue state officials, either the Attorney General or relevant enforcer of the law, under ex parte Young provisions for prospective relief. The Supreme Court case that solidifies the right to sue state actors over enforcement of unconstitutional statutes, not the state entity itself, due to sovereign immunity. The threat must be credible, not imaginary, and the intended conduct must arguably violate the law while being constitutionally protected. In Hughes v. Lee, it was the governor and the attorney general as the main defendants. But I'm not surprised. We have seen the General Assembly fail to obey a consent decree issued by a federal district court and agreed to by the Attorney General of Tennessee. from Beeler v. Jeff Long, quote, the challenge scheme regulating the possession and carrying of handguns that restricts individuals aged 18 to 20 years old from carrying handguns or obtaining permits to carry handguns on the basis of age alone violates the Second and 14th Amendments to the United States Constitution. Defendants shall implement any and all procedures necessary to accept and review enhanced handgun carry permit applications under 3917-1351 and concealed handgun carry permit applications under 3911-1366 submitted by individuals 18 to 20 years old, and shall not deny issuance of such a permit on the basis of age alone, close quote. The General Assembly passed a law last year then, HB 1332, that allows 18 to 20-year-olds the ability to perfect only an enhanced permit, failing to meet the order of the court and the agreement by Jonathan Scarametti, State AG, and Jeff Long, Commissioner of the Department of Safety, to enforce the court's order. AG Scarametti did not defend the state against unconstitutional enforcement of Second Amendment or 14th Amendment of infringements, but now wants to limit such suits in state court. The fiscal note on House Bill 1971 was not significant, so it did not make or save the state any money. It is apparent that the legislature thinks they can do whatever, whenever. We will see about that. Check with your elected employees about their vote on House Bill 1971, Senate Bill 1958. You will know them by their fruits.